Hello, everyone, and welcome to Sutherland's webinar on Don't Be the Next Cyber Attack Victim, 5 Practical Steps Every Company Should Take Now. This is the second in Sutherland's series on trends in financial technology webinars. I'm Mary Jane Wilson-Bilik, and I'm being joined today by Sutherland's Mark Thibodeaux and KPMG's Fred Rica, who's head of their Information Protection and Business Resilience Group. A couple of housekeeping items. If you want to receive CLE credit for the webinar, please download the CLE sign-in sheet and evaluation form from your viewing console and follow the instructions for submission. You can get 1 hour of CLE credit from Georgia, Texas, and it's pending in Virginia. It's also available in California and New York through the approved jurisdiction rule. If you require CLE credit outside of those states, please use the individual attorney application for your respective states along with your certificate of attendance and the program materials. I also want to mention that the slides will be available and posted on our website in about a week. And if you have any questions during this webinar, please submit them using the Ask the Question text box on your viewing console. So my name is Mary Jane Wilson-Bilik. I'm an insurance regulatory and federal security lawyer here in the Washington office at Sutherland. I've been representing insurance companies and their affiliates for about 20 years before the SEC and various state insurance regulators, usually dealing with some hot topic of the day, whether it's market timing or unclaimed property, and now cybersecurity. I think many of you know me from the work I've done with your companies on Rule 38A1 and 20647. So let me turn it over now to Mark, and take it away, Mark.
Hi, I'm Mark Thibodeaux. As Mary Jane noted, I'm an attorney with Sutherland. I'm Deputy Practice Lead for Sutherland's Privacy and Data Security Practice. And I've been working in data security for about 25 years now, including about 10 years as Chief Information Officer of Enron. And so I think this will be a very exciting and interesting discussion. And I'll turn it over to Fred so he can introduce himself.
Well, thank you, Mark, and good afternoon, everyone. My name is Fred Rica. I'm a principal with KPMG. I lead our cyber risk and threat intelligence practice. I've spent my entire career, the last 25 years, focused on helping clients deal with cybersecurity matters.
We do want to mention that it's National Cybersecurity Month.
It is. So all month of October, you'll be hearing lots of things about cybersecurity, and what a great way to kick it off with this presentation. So to begin with, we'll talk about during this presentation the nature of the cybersecurity threat, what's going on out there and what you should be worried about, who the attackers are and what they're going after, those sorts of things, the legal and regulatory consequences of the fact that there are hackers out there actively attacking U.S. companies, and most importantly, perhaps, some practical steps you can or hopefully already are taking right now to protect yourselves or at least to mitigate the risk to you. So no doubt you've seen the headlines in the newspaper, on TV regarding big security breaches that have happened, particularly in the past year with Target, Home Depot, and other big companies being attacked. A lot of these attacks have been going after credit cards specifically, but that's not the only thing hackers are after, and we'll talk about that some more a little bit later. These attacks have also proven very costly for some of these companies. Home Depot is estimating they're going to spend more than $60 million recovering from their breach. Target spent somewhere in the neighborhood of $50 to $60 million themselves. And it ultimately cost several executives at Target their jobs, amongst other things. I always take that with a grain of salt because Target was also having a bad year based on their expansion into Canada, so I'm not sure it was entirely the cyber breach that led to that, but nonetheless, it was certainly a factor.
Yeah, you know, Mark, it's Fred. I'll add to that. It's becoming clear to us that more and more this is becoming a top of house issue. We spend a lot of our time now talking to boards of directors, advising C-suite executives, talking to OGC about this matter, and even as recently as 12, 18 months ago, this was not a conversation we were having at that level of the organization. So it is just clear that this has moved right to the top of the house as far as an imperative that our clients are dealing with.
Great. Thanks, Fred. So who are the attackers? Who is after your data? Richard Clark, former White House securities czar, came up with this acronym CHEW, C-H-E-W, to describe the attackers, being criminals, hacktivists, espionage, and war. The criminal category is an awfully broad one because it covers pretty much any kind of hacking activity regardless because it's all against the law. Nonetheless, when Richard Clark's talking about it, he's mostly talking about your Russian mafia, Asian gangs, teenagers who have too much spare time on their hands who want to break into your network just to prove they can. And I don't say that as a facetious thing. I actually had a client in the past year whose website was broken into specifically for that purpose. It was broken into by a group of teenagers who wanted to prove that they could break into a site that one of the more famous hacking groups had not been able to break into. So they were just doing it for the credentials of saying we did it. Hacktivists, of course, are folks like Anonymous and other social activists that want to break into your websites or disrupt your business in order to further their social causes. Espionage has actually been with us since the beginning of the Internet, the commercial Internet back in the early 1990s, and continues today on both a government-to-government front and a business-to-business front, and every combination thereof. So there's actually government security agencies that are breaking into businesses to aid the businesses in their country. So there's a lot of that going on. And then the more recent high-profile group that wasn't well known in the past, at least, is this war aspect where either government actors or pseudo-government actors are attacking the cyber infrastructure of other countries in order to provide themselves with a strategic advantage, potentially either economically or in the event of some kind of actually fighting going on to provide them the ability to disrupt communications and or take out the electric grid or the water supply or things like that.
So this has become much more of a national security issue and raising issues, particularly for SEC lawyers, about what you disclose if, in fact, what you know about is somehow confidential or obtained through some kind of, secured briefing that you've had with top government officials. A big issue for a lot of companies.
And we'll get into that a good deal more later in the presentation. So who are all these hackers attacking? The answer is they're attacking you, whatever business line you happen to be in. The things that make the news are the ones that have lots and lots of victims. So where lots of credit cards are stolen, that's certainly going to make the news, but that doesn't mean other companies are not being broken into. The financial sector in New York has been facing all kinds of attacks, trying to basically disrupt their communications network and make it impossible for people to do online banking and things like this. The healthcare industry is facing attacks on people trying to get into the critical healthcare information of people, not just because that's interesting information to have, but also because the health records make it really easy for somebody to steal your identity if they can get a hold of them. They basically have all the information about you in order to go and create their own bank accounts, their own duplicate identity.
And of course, as companies go more and more toward big data and try to gather more and more information, become more information rich in their platforms, especially the big insurance companies, this is going to become they'll be more and more of a target.
This particular slide that we have up right now makes mention of a hacking group called Comet Crew, and Fred, you probably can speak to this as well, but Comet Crew is thought to have been affiliated with the People's Liberation Army and may actually be a unit of the Chinese Army. So that's the kind of people who are out there attacking you. So well-funded, well-resourced groups of individuals, as well as teenagers with too much time.
Right.
Yeah, and I think that's right, Mark. And I just think there's no doubt anymore that, some of these attacks are nation-state sponsored. They're organized crime. I mean, we used to sort of anecdotally think that's what it was. We absolutely know now that we've got evidence that that, as you said, it's a very organized, very well-funded, very persistent adversary. And I think, as you said, the credit card information always makes the headlines because that affects all of us. But appreciate that every organization has data of value, and there are actors who are after that data. I've worked with organizations that have lost R&D information. They've lost intellectual property, and the cost of that can be just as high as if you lose some credit card information. Interestingly, as we look forward to sort of where the next generation of hacking is going to take place, it's as we move to the Internet of Things, device hacking is becoming a big topic right now in the underground. And so if you think about the types of devices that we rely on today, for example, medical devices, most of which now have some kind of IP, Internet Protocol connectivity to them or some type of Bluetooth connectivity to them. Imagine if I could drive by the dialysis wing of a major hospital and just shut down all the dialysis pumps or all the insulin pumps. Imagine if someone could drive by your house and take over your in-home security system and surveillance. And so it's all important, it's all valuable, and these guys are smart, and they're just going to keep escalating the attacks. And so the idea is not to get caught in the notion of, well, we don't process credit cards, we don't collect credit card data, and so we might be okay. That's a bit of a false sense of security.
Which segues really well into our next slide in this deck here, which is talking about why individuals want to hack you. A PC has a great variety of values to it, to the hacking community. And this is just some examples that were actually credit where credit is due. This was created by a guy named Brian Krebs, who has a very interesting security blog on the Internet. You should look him up if you get a chance. Very good information. But this particular diagram shows things like, of course, they're trying to get after your financial information. If you're using Quicken or doing online banking, or you have your credit card information on your PC, they're trying to get that kind of information. A sort of novel attack that's been occurring in the last couple of years is hackers will actually break into your PCs, your company's PCs, encrypt the data, that is, scramble it up, have the password to themselves, and offer to sell you the password to your own data for a cost. Payment accepted in Bitcoin or PayPal. So there's that kind of activity going on. And then there's this third aspect that hackers are attacking computer systems not for the value of what's on those computers themselves, but to use the processing power of those computers to attack others. They either hijack your website and set up an online marketplace dealing in drugs or weapons or things like that, or they can use your website to look like another legitimate company's website and fool people into providing their credentials to the service. So there's lots of reasons that hackers might attack your computer systems beyond the obvious that they want to steal your data. The traditional view of security has been sort of this, I have a castle that is my company and my company's network, and there's a moat around it that is my demilitarized zone is the common term they use for computer security. And there's a firewall in there, and that firewall is the moat to my castle. I don't know that the computer security scenario has ever been that simple in reality because, as we'll see on the next slide, there really are a lot of ways into your network. It's not a castle with a moat. It's a marketplace where people are coming and going, and data is coming in and leaving, and individuals are coming in and leaving. And you've got laptops, and you've got thumb drives, and you've got portable hard drives, and you've got smartphones, and all these devices that can carry your company's critical information that easily walk out the door.
And you've got vendors.
And vendors, as Target found. One of the interesting aspects of the Target attack is that it wasn't, in particular, something Target was doing wrong. The initial attack was actually on one of Target's vendors, and the attackers then used that access to get onto Target's network. Now, the vendor had more access than he should have on Target's network, so that was Target's problem. But the initial attack was actually on the vendor. And so you've got contractors, you've got consultants coming in, and any of these individuals have some level of access to your network because you've given it to them. And so an attacker's not going to waste their time trying to guess passwords like you see in the movies if they can get somebody to tell them their password or fool them into giving them their password, and then they've got access without having to do any work.
You might not even know they're there for years.
And the attacks are getting more and more sophisticated because of that. Attackers are actually going after individuals at companies with intelligence on who those individuals are, what their jobs are, and what sorts of information they may be dealing with. A particular type of attack that's been around for years and years called phishing, which is where somebody sends you an email that looks like a legitimate email, but when you either open the attachment or click on some link in that email, it takes you to a site that then attempts to steal your credentials or run software on your computer like a virus or something like that. Those attacks have morphed now into what are called spear phishing, which is an email that's targeted to a specific individual with the knowledge that that individual has a particular position at the company, and so the email is crafted to try to address that individual directly, rather than just being some generic, I'm a Nigerian minister and I have money I'd like to get out of the country sort of thing. And then there's another variation on that where the attacks are aimed specifically at corporate executives, and the term of art for that now is whale phishing, which I love, or whaling. And then there's another form of attack that's called water holing, and water holing is where the attackers don't go directly after your company's infrastructure, your computer systems at your business. Instead, they attack the websites or computer systems of companies you're affiliated with or companies that happen to be around you. A famous attack along these lines occurred at a company out on the West Coast where hackers broke into the website of a Chinese restaurant that was essentially next door to the business. And so the hackers figured out that a lot of the company's employees would be going to that website. They hacked that website, which didn't have very good security, hijacked the Chinese food menu, and then when people at the company downloaded the menu, the attackers were in. So there's lots of types of attacks, and the biggest problem right now is that we have so many people already on our computer systems that have legitimate access. We're our own worst enemies these days.
So where are the regulators in all of this? And what we have, for those in the insurance world, we have a very familiar picture of a hodgepodge of federal and state regulators who are trying to catch up and keep up with all that's going on. The sort of the foundational rule in all of this is the Gramm-Leach-Bliley privacy and safeguard rules that are adopted by the HIPAA and FTC and the SEC and Reg SP. You know, these are the ones where you have to preserve customers' privacy or, give privacy notices if you're going to be sharing their information. But there's also the safeguard rules, which require that, you make sure that you are protecting the customer information and that it will not be deleted or destroyed and that it cannot be stolen, i.e. hacked. So we have those kinds of rules that are out there, but what these rules don't address, and what has really become very obvious that they don't address, is managing the incident of when there is a cyber incident, and what is the recovery? How resilient is your company or your systems beyond protecting customer information? Just to go a little bit more about what are some of these regulations on the state side. We have breach notification laws. So if you have a breach as part of your recovery, you do have to give notification. 47 states have them. They have different triggers. They have different time requirements. They have different persons that you need to notify, sometimes the state insurance commissioner, AG, all kinds of different folks. You need to be on top of that. There are also data protection laws in about 10 states, Massachusetts being the most restrictive. It is a good rule to look at.
Actually, Florida now has a more restrictive law.
Okay, I have to revise my slides there. Okay, so we have some very restrictive requirements, and we also have state insurance departments who are doing some inquiries, but not a lot of activity at the NAIC. We still have just some model regs that are the Gramm-Leach-Bliley regs, but we have New York 308 inquiry into both banks and insurance companies by the DFS. And they recently, in I think it was May of this year, issued a report on what they found on the banking sector. It's a report worth taking a look at. I mean, they are criticizing corporate governance and, really raising, I think, in an intelligent way, some of the issues involved here. So, but what we have essentially is a reasonableness standard. We have some specifics with data breach and data protection, but it's very much a reasonableness standard, and that is, as we all know, very much of a moving target. And the only other thing I wanted to mention is this has become the focus of FSOC, for the Financial Stability Oversight Council, that it is one of their major risks that they see in the nationwide, and it's also identified in the second FIO report, the Federal Insurance Report.
And one quick thing I wanted to add, too, because it is really a complicated landscape on the breach notification side. You can get charts that have the 47 different state breach notification laws, but depending on what industry you're in, there could be additional requirements. For example, the Connecticut Department of Insurance wants to be notified within 5 days of a breach, which is much shorter than the Connecticut General Breach Notification Law, which is essentially in a reasonable amount of time.
Right. Let me talk about a little bit about what's been going on the national level, which I think is important to sort of see where we are. In early 2013, President Obama issued an executive order on improving critical infrastructure cybersecurity, talked about strengthening the readiness and cybersecurity practices. It gave expedited security clearances for some, in-house personnel. And it was also a charge to the Commerce, the NIST, which is the National Institute for Standards and Technology, and Homeland Security to develop a framework. They came out with that framework earlier this year, in February of 2014, and it really has been hailed as a really important resource and a benchmark. It was presented to the NAIC in the March meetings, and is being looked at as potentially a standard of care for corporate management. It has very familiar themes in terms of you need to deter, in other words, try to prevent attacks, detect what you have, what activity there might be. You have to protect your systems, you have to respond, and you have to recover. And also enables companies to be able to assess where they are, and they get on a scale of 1 to 5 from where you are on that scale.
What it's not is it's not a how-to list.
Right.
It doesn't say if you do this, you'll be secure. It's basically a list of questions you ought to be asking.
Right. That then formed the basis for what the SEC did in March. The SEC held an SEC Cybersecurity Roundtable, and Chair Mary Jo White talked about the need for partnership between the government and the private sector, and announced various cybersecurity initiatives. A big one was in April of this year, where they SEC examined 50 broker-dealers and investment advisors, many of whom were, or some of whom were affiliated with insurance companies, and the SEC asked and published 26 very tough questions that they wanted companies to be able to address. And some of those are very familiar for those who are involved with any kind of compliance, the 38A1 or 20647. It requires, do you have written information security policy? Do you have written business continuity policy that addresses what might happen if there's a cyber incident, or how are you going to recover? Have you done periodic risk assessments, both of your own system and of those of the vendors? What are you doing to protect the network and all that we've talked about in terms of mobile media, and what's your data destruction program? And they urge a holistic approach that you involve not just the IT guys and compliance, but you bring legal in, and you understand the kind of oversight that's required. And sorry, Mark, you just don't leave it to the IT guys.
No, I mean, that's a key point. Cybersecurity these days is not just an IT problem. I talked earlier about how you don't have a moat around your castle anymore anyway. So all your employees need to be involved in it, and we'll cover that some more when we talk about the specific steps you can take.
Right, and that's kind of coming from the realization that we're seeing on the federal level is from what the regulators are going to be expecting of companies. There is also the FTC for those that are not subject to SEC or NAIC regulation, and FTC is a question of whether a bad cybersecurity is an unfair and deceptive trade practice. While it's still in the courts, whether in fact this is something that the FTC could enforce. They have gotten large companies to agree to certain consent orders that are getting quite expensive. Mark, did you want to talk about labs?
Yeah. Companies going back for several years now have been essentially in an effort to cooperate with the FTC and its enforcement actions regarding cybersecurity, agreeing to consent decrees that the majority of which, and certainly all the recent ones, require 20 years worth of investigations or assessments of the security.
Going forward.
Yeah. Every 2 years for 20 years, you must have an assessment done. Hopefully a lot of companies are having cybersecurity assessments done anyway, right, Fred? But having to have one that you're going to produce to the FTC on a biannual basis is a step beyond.
Yeah, and I've helped a number of clients navigate through this, and it is time consuming and it is expensive, and it's just it's 20 years of ongoing work, and it can consume a lot of cycles for a lot of people to comply with these orders.
And then there's the cost of either fighting the FTC, which we on this slide have a note about a company called LabMD. If you're not familiar with the case, LabMD was a relatively small medical testing laboratory that lost a laptop. Individuals' medical information was exposed. You might think that would be a HIPAA violation and that therefore the Department of Health and Human Services would get involved in trying to enforce that. But the FTC decided they had a role in that case as well, based on the FTC Act, Title V, declaring that having that bad a security was in and of itself an unfair trade practice. LabMD has tried to fight that case with the FTC, claiming the FTC doesn't have jurisdiction. They declared earlier this year that they're going out of business because it's cost them so much to fight the FTC. And then on the other side, where you enter into a consent decree and agree to do certain things, make sure you follow through, because Google didn't, and it cost them $22.5 million because of it. So on the litigation side, on the non-government enforcement side, anytime there's a breach, there's always a plaintiff's attorney looking to rush in and file a class action to try to recoup something from the companies that are responsible for the breach. To date, those class actions have largely been unsuccessful. Most courts are finding that there's not a cognizable harm that's at least something worth litigating, because most people will spend a couple of hours on the phone with their credit card company getting their credit card replaced, or they're signing up for the credit monitoring service, and courts have decided that's not enough damages for them to agree to certify a class and move it forward. However, there have been a couple of notable exceptions to that. One in Florida, where a settlement was reached and ultimately blessed by the 11th Circuit in the case of some stolen laptops, and the 11th Circuit ruled that there were sufficient allegations of damage in the nature of identity theft damages. Again, it's the kind of thing that I just described, spending a couple of hours on the phone with the credit card companies and getting credit monitoring set up for multiple years, but that was sufficient under Florida law to constitute a basis for the settlement. And then a West Virginia court recently found standing for class certification, despite the fact that none of the named plaintiffs had any evidence of actual or attempted identity theft on themselves, and no evidence of actual economic loss to themselves. But nonetheless, the West Virginia court basically decided that the possibility of identity theft in the future was significant enough that it constituted a basis for class certification. And then, of course, there's also the potential that you have some contractual obligation to another party to protect their data, whether it's a counterparty in a business transaction or a customer. There may be damages under a contractual basis that you could be facing. To date, class actions have come up with at least 86 different causes of action to go against companies that have had data breaches. So the plaintiffs' attorneys are getting very creative. The cost of data breach, this chart, which is taken from a company called the Ponemon Institute, which does annual surveys on the cost of data breaches. is not insignificant. These numbers are in hundreds of dollars, but it's hundreds of dollars per customers whose identity has been stolen or whose data has been stolen. And as you can see, healthcare is still the most expensive industry to have your information stolen, but financial services are right up there in the top 5. When you're talking about tens of thousands or hundreds of thousands of customers whose data are stolen, those numbers add up quickly. The costs are also increasing. In 2013, the average cost per record stolen was only about $188, and it's gone up in 2014 to $201. You notice that on this chart or this page that it talks about the cost of breaches in the rest of the world. A lot of that's due to the fact that a lot of countries still don't have laws that recognize a data breach as a loss that you can do anything about if you're a customer. But the U.S. certainly has those laws. The EU has got some and is getting more. And a wide variety of interesting countries around the world have laws, although it's hit and miss as to where those are. So, Fred, why don't you help us out with what you can do right now to try to mitigate some of these risks?
Yeah, thanks, Mark. I mean, I think you've painted a very interesting picture. And, at KPMG, our view is we call it assumed state of compromise, in that you're either about to be breached, you're in the middle of a breach, or you've been breached. And if you go into your planning and if you base your actions on that hypothesis that you're perpetually in one of those 3 states, I think it drives perhaps some different behavior than what we've done in the past. And I like this quote from President Eisenhower. The other quote I like about planning is, everyone has a plan until they get punched in the face. So maybe let's talk a little bit about what to do when that happens. And so if we just move ahead a little bit, my message today is if you take nothing away from today's discussion other than I have never in my 25 years seen technology solve a security problem. It's just clear this is no longer a technology problem. Many of the breaches that Mark had talked about earlier, and many of the ones that we investigate, so much of the cause is behavioral. People's willingness to click on a link, people's willingness to take a thumb drive and plug it into their computer. I often make the analogy, people are very comfortable picking up a thumb drive, sticking it into their laptop, and let's see what happens, or let's see what's on it. I say, if you were walking down the street and you saw a needle on the sidewalk, would you stick it in your arm? And so the first step in dealing with some of those behavioral matters is what is our team? What is our information security team? What is our incident response team going to look like? And in the past, we were very focused on a specific role in an organization called the Chief Information Security Officer. And that role is still very important, but to delegate the notion of our information security team strictly to that person or that team is probably a mistake. And so you can see here there's a lot of different functions and capabilities and executives that we need to have involved not only in our incident response plan, but really broadly in our information security plan and program. I started the conversation by saying a lot of our conversations today are with board members and with C-suite executives and with OGCs, and so they all have a role in how we're going to structure our program and conveying to the entire organization just how important that program is. And so once you've put your team together, the next piece of this is having a good understanding of where our information assets are. A lot of my clients who have suffered breaches, what happens is that the data that gets compromised, within the systems it was designed to work within is pretty well protected. But what happens is it gets outside of those systems. It gets into what we call an unstructured format. So it starts getting into spreadsheets. It starts getting into Word files. It starts getting into email. And that's typically where we start to see the breakdown. I could probably give you dozens of anecdotes about clients who had Social Security numbers stored on laptops, PHI stored in emails, and that's typically where we see that getting compromised. And so it's important to understand like three things. One is, do I have a way to value my data? Do I have a data classification program that helps me to understand, look, based on certain characteristics of my data, it falls into a certain bucket, and if it's in that bucket, it needs certain controls around it. And once I've done that exercise of understanding what's important to me and how I want to protect it, I then have to think about it because data lives in a couple different states, and so I need to think about it in terms of, am I protecting the data at rest? Am I protecting the data while it's in transit? And am I protecting the data while it's in use? And when I think about those three states of data, thinking about what other obligations I might have to protect that data, what vendors or third parties are getting access to it. And it's interesting, you cannot transfer brand risk. So even if you sent the data off-site, and even if you have a third party or a vendor who's responsible for managing it, at the end of the day, customers and consumers view it as your brand. And so you simply cannot transfer that risk to your brand. And so it becomes important to understand who's touching this data and what they're doing with it, and have I specified the controls that they need to have in place over it such that they're protecting it the way I would protect it if I had it myself. And so, we've got our team together. We're starting to.
I just want to jump in real quick and make a note that increasingly I'm seeing contracts that have clauses in them that at least nominally obligate companies to protect the data of counterparties in business transactions. And it's easy to write those clauses in and assume that somebody in IT is going to take care of those things. But number one, the IT people aren't always aware of those obligations existing. And number two, somebody who has a business role in that transaction needs to be making sure they know where that data is and whether they've got IT or whoever needs to be involved in protecting it adequately as they've agreed to in the contract.
Yes, and we've seen appendices to some agreements where large amounts of data are going out, even to regulators, where there have been agreements about the kind of security that would be around that data.
Yeah, so I think contracts go into drawers all too quickly without somebody doing the ongoing follow-up to make sure the data is still being protected on an ongoing basis.
Right.
Yeah, and I think, Mark, that's an excellent point. And one of the things that I've seen evolve is not only having those contracts in place, but making sure that the contracts have a mechanism such that we can go and validate that those controls are in place. And so whether that's an on-site audit, some type of third-party letter, but really structuring the contract in a way that we have the ability to monitor the third party and ensure that the controls that we expect to be in place are in place and are functioning the way we want them to. And so, we've got our team together. We're starting to get a handle on where our assets are and what's important to us. And so the next piece of this is really making sure that we've got, and we've highlighted these two words for a reason, comprehensive and written policies and procedures. So much of what we need to do in this space is communicating to our stakeholders the expectations we have, the behaviors we expect, and what we're going to do if we have a problem. And so not only have we seen regulators taking a closer look at what those policies and procedures are, but we've found it to be immensely helpful to our clients, not only to go through the exercise, in and of itself, going through the exercise and documenting these policies and procedures can be eye-opening in terms of what we need to do and who needs to do it. And so much of this falls apart because roles and responsibilities are not clearly defined. And having those written policies and procedures can go a long way towards avoiding that problem. And I know, Mary Jane, I know you had a couple of comments you wanted to make on the importance of having written policies and procedures.
Yes, so just that we can expect that state and federal regulators will be looking at your policies and procedures. That is part of when the SEC, the OC department, did the inspection recently of 50 brokers, dealers, advisors. Some companies were given deficiency letters because of their failure to have sufficiently robust written policies and procedures. They might have been sitting in the IT department or been with the CIO and not have been really vetted and pulled into your compliance programs where you will be doing risk assessments and doing annual assessments and written reports that have to be done on whether those policies and procedures are effective. And those are familiar for those who have been through the SEC rulemaking since 2004. You're familiar with all those requirements, but they haven't been really made robust for the cybersecurity side of the business.
Yeah, and a couple of quick notes related to that are that to the extent that there are laws governing cybersecurity, and they're not a lot, but the ones that are out there, as Mary Jane noted earlier, generally have a standard of reasonable security. Having good, robust cybersecurity policies are certainly a part of reasonable, however that ends up being defined. The second part of that is a lot of times these policies and procedures are written by or reside in, as Mary Jane said, either IT or sometimes HR has a role in it because they do all the personnel policies. But that somebody beyond those groups need to be looking at these things, because this is where the FTC enforcement has been coming in, is basically holding companies liable for not living up to the standards they put in writing. So just because you have a cybersecurity policy isn't enough. You have to actually be doing what you say you're going to be doing in that, or you have committed a deceptive trade practice, and the FTC or state attorneys general will come after you.
Yeah, and I think it's exactly what you said, Fred, about having defined roles and responsibilities. I think that's a critical part of these policies and procedures, not just saying we're going to do this, but who's going to do it, how and when, and what are the exception reporting if there's a problem. If I could, I just want to take a moment to pull us back. If you're getting CLE, I wanted to just let you know that the confirmation code for this webinar is Patriots, as in New England. And please use this code in your sign-in sheet. It's available for download from your viewing console.
Back to you, Fred.
Back to you.
Okay, and thank you guys for that insight. The last thing I'll say around policies and procedures is there is a lot of good guidance and a lot of good information available to help guide the development of programs like this. We talked about the NIST standard earlier. There's ISO standards. KPMG, we have our own framework that we help our clients with. And so the point is there is a lot of, you don't have to start from zero. There is a lot of good information out there, and building your program around one of those recognized standards will certainly go a long way towards making that program implementable, and will go a long way towards answering regulators' questions about why you're doing what you're doing. All right, so we've got our team together. We're starting to get a handle on what our data is. We're putting our policies and procedures together, and so now we're probably at a point where it really makes sense to start assessing our current posture. And so the idea, and there's many ways to come in and look at your security posture. There are penetration tests and red team exercises. I'm sure you've all been involved in those. There's maturity assessments. There's baseline assessments. There's gap analysis. The point to all of this is you want to come in and really take an objective measure of where your program is today. Understand where you have gaps, understand where you need to mature capabilities, and start to put a roadmap together that says, okay, so we're here today, we need to get to there tomorrow. What is the plan? What is the time horizon? Who are the key stakeholders? Who's responsible? How much is in it cost? And what are we going to do to close that gap? A couple things to consider. I've worked with a lot of organizations where when they have that concern that they may be in the middle of a breach, or they are about to be breached, and they take on these posture assessments. Sometimes it makes sense to do that work under privilege. You may not want the results of that study to be discoverable if you think there's a potential for future litigation. Also, consider that if you do uncover something during that assessment, some evidence of a breach, whether active or prior, you may have some other obligations around that. And so for those reasons, sometimes it makes sense to do that work under privilege. And I am not an attorney by any stretch, so I would not constitute that as legal advice. But Mark or Mary Jane, I don't know if you have anything else you'd like to add in terms of the notion of doing some of this work under privilege.
Yeah, I'll give you legal advice on that. So one aspect of this, which not in the context of a cyber breach, but in the context of other incidents I've seen far too often, is that when a breach happens and an investigation begins, the investigations are all too commonly led by IT. And IT folks are really good and technical and know their systems and do their best possible to keep your systems up and running and doing what they ought to be doing. They're generally not experienced investigators. And so they have a tendency to document a lot of things and send a lot of emails, which may or may not be of relevance to what caused an incident, but will certainly be of interest to plaintiffs' attorneys when it comes to court, and they'll read all those emails into the record.
And be of interest to the SEC as we move forward with developing whatever the requirements are that the SEC wants to see.
So I think at a minimum, when an incident occurs, that, again, it's part of having your team in place ahead of time, that legal has a role in this, and that part of that is making sure that the investigation sticks to what it's supposed to be investigating in the breach, and that communications are just factual communication regarding what happened and when it happened and how it happened.
Right. And to the extent that these are part of a company's compliance procedures under the federal security rules, there will be a role for the chief compliance officer, and there are questions about whether some of these incidents might need self-reporting to the SEC as this develops. I don't think we're at that stage yet, but we have to be considering those issues going forward. And
then again, knowing the various states' laws and all the various jurisdictions that have breach notification requirements, knowing which data in which states trigger which requirements, and knowing that even though only 47 states have notification requirements, not including the South Dakota, New Mexico, and Alabama, even if you have a breach in one of those three states, there are state laws like Texas that require you to notify citizens of those other states that aren't covered. So if you're doing business with Texas, you may be obligated under Texas law to notify Alabama citizens.
Yeah, so thanks, Mark and Mary Jane. And so just as a sidebar, there were a couple of questions. The passcode for CLE is Patriots, as in the football team from New England. Just a last comment on as you assess your security posture. I get this a lot. Well, Fred, we're ISO compliant, or we passed our, SOC 1, or all of those compliance activities, I think, in today's environment need to be viewed as a good start and not an end state. And I've worked with lots of clients who have, passed lots of audits and gotten lots of certifications and still have security incidents. And so important to remember, compliance is simply a good start, not an end state at all.
And that's one of the things noted in the NIST framework, too, is that it has a concept, and as do many of the frameworks for cybersecurity, have a concept of maturity model, so that even if you're doing something in all the areas, you may be at level 1, which is the entry level, the bare minimum that you ought to be doing, and you can go all the way up to level 5 under the NIST standard, where you're a very robust, proactive organization taking care of things before they occur.
Yeah, and I think that's a good point, Mark, because I get this question a lot from clients. We'll come in and we'll do some assessment work, and we'll discover that various components of their program might be at a very low level of maturity, a 1 or a 2, sort of ad hoc, not very formal. And I always get the question, well, what do we need to do to be a 5, to get all the way to the upper right-hand corner of the quadrant? And my general answer is you probably should not aspire to do that, because at some point you'll be spending more money than the value of what you're trying to protect. And so as you think about assessing your security posture, and as you think about steps you want to take, capabilities you want to mature going forward, it's important to do that with a lens of risk management and making sure that we're not overspending or overinvesting in areas and perhaps spending more than the value of what we're trying to protect. So we've done all this now. We've got our team together, and we understand our data, and we've put our policies together, and we've done some assessments, and we feel pretty good, and yet we still have a problem. So what do we want to do in the event that we have a breach and that we have an incident? And so, as I started my comments, assume you're going to have a breach eventually. Just remember, we have to get security right all of the time. Every day, every minute, all the time, we have to be right. The bad guys only have to be right once, right? They just have to find that one area of vulnerability. And so the odds are stacked against us right from the beginning. As you think about, putting your plan together, it's interesting. We do a lot of tabletop exercises with clients to help them model their incident response plans. And in the past, so much of that was focused on the technical aspects of running an investigation. So how are we going to image hard drives? How are we going to quarantine machines? How are we going to stop the data exfiltration? And the truth of the matter is we've gotten pretty good at that. Those things are there's good guidance in how to do all of those technical activities. So much more of what we're helping clients deal with now, and what we've learned from the big data breaches of the last year or so is making sure that we've got a strong communication plan in place. So what's the call chain? When is OGC going to get involved? When's the CEO going to be notified? When is outside counsel going to be notified? What's the chain of events that is going to trigger those specific activities? Who's going to talk to the media? When are they going to talk to the media, and what are they going to say? Do we have our PR and communications plan in place? And I think one of the things we learned specifically from the Target event was the inaccurate or untimely communications can be just as damaging as the event itself. And so much of what we do has been helping our clients think about how, what they're going to say, who's going to say it, and when they're going to say it. And then we've seen more and more dress rehearsals of these types of events. So just like, periodically they ring the fire bell and you have to leave your building, as a fire drill, we're starting to see the same thing on the cyber incident front, where clients are running through drills to make sure that we've got the right playbook, it works well, people understand their roles and responsibilities, and so we feel pretty good that so things that clients think about that perhaps get overlooked. So if we think we've been compromised, we probably can't use email to communicate with each other. We have to assume that our internal email systems have been compromised as well. Do we have an alternate communications plan in place? Have we given our executives, a Gmail account that we're going to use in the interim? Have we agreed that we're going to communicate via text? Do we have the conference bridges ready to go? So all those types of details that can make a big difference in the early hours of responding to an incident are the types of things that go into having that detailed response plan in place. And then finally, this is security really needs to be viewed as a process, not an event. And so I get this question a lot. Fred, if I had $1 more to spend on security, where should I spend it? And I've always said that training and awareness will probably give you more return on investment than almost anything else that you can do. We've learned that many of the breaches that have happened are the result of human behavior. We've learned that everybody in our organization has a role in cybersecurity, and reinforcing that message on a regular, frequent basis can go a long way towards helping improve our security posture and helping to defend us against potential incidents. And so, Mark, I think with that, we are at the point in the program where perhaps we could, in the few minutes we have left, we may want to open it up for some questions. So thank you.
Yeah, thanks, Fred. So one of the things before we get to questions, and we want to be respectful of your time, we're getting close to the top of the hour here, is I wanted to mention that, as Mary Jane said at the start, it is National Cybersecurity Awareness Month, and to that end, Sutherland, again with the able assistance of our friends at KPMG, are putting on an event in Houston on October the 16th, where we're actually going to be doing a simulation of a cyber event. And we're basically going to have people playing the roles of Chief Information Security Officer, General Counsel. We actually have an FBI agent coming to play a role on the panel, outside security consultants and outside attorneys to walk through what you do on the day of an event and dealing with the aftermath of a cybersecurity incident. So if any of you are in the Houston area or can make it down to Houston for October 16th, I encourage that to you.
Do you have any questions?
One of the questions we had here is whether states' attorney general are getting involved in cybersecurity enforcement or not. And I think I'll take that one. There are certainly involved where there's a breach that occurs where inadequate notification is happening because there's usually statutory fines for not notifying people on an untimely basis. There are a few states attorney general, California being a particular and always the likely candidate in case of privacy issues, where they are using the state version of the FTC Act, their state unfair and deceptive trade practices, to go after companies that have had a breach because they didn't have adequate security in place. But not a lot of activity on that front.
Okay, I have one here. It says, I'm a separate account compliance officer. Should I include cybersecurity in my policies and procedures in my compliance manual? The answer is definitely yes. This is subject to SEC Rule 30 under SP. There usually is some very basic information in a compliance manual about that requirement, but the SEC has filled it out quite a bit in their recent legal alert that they published in April of this year. And so we encourage companies to take a fresh look at their cybersecurity policies and procedures in their compliance manual.
I had one more that was asking if these class actions and data breaches have been so unsuccessful, why do plaintiffs' attorneys keep filing them? I guess the short answer to that is hope springs eternal. As I noted earlier, they've come up with at least 86 different causes of action to try to file these things under. And as I noted earlier, too, there's been some encouragement from a couple of state courts under that front. So, you know, who knows? There could be significant damages found in some of these cases.
All right. Well, I think we're approaching the end of the hour. I want to thank everybody for their attention and for participation in the webinar. Fred, thanks very much for your attendance. Appreciate it from Dallas. And Mark, thanks for your help on all this. As a reminder, I want to let you know that you can get CLE credit for the webinar. Just download the CLE sign-in sheet and evaluation form from your viewing console and follow the instructions. If you have any questions from the seminar, please contact any of us. And I'd also like to invite you to join our third installment in our webinars for financial services industry. It's on Tuesday, October 14th, and it's called For Whom the Bell Tolls, Telephone Consumer Protection Act Litigation in the Insurance Industry. And they'll be talking about emerging trends in the recent restrictions applying to insurance companies that use automated telephone dialing systems to communicate with their customers and other hot issues facing insurers under the TCPA. And we encourage you to join that. But thank you again for your attention, and hope you've enjoyed the presentation, and good afternoon.